Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to discuss the limitations of employment agreements in the context of having been fired, laid off, or otherwise terminated from your job. And the reason we need to discuss the limitations of these employment agreements is because all too often, employees look at them as the end-all and be-all of the employment arrangement. And far too often, even the employers and the employer's legal counsel will take those agreements and say, this is what you agreed to, and for that very reason, you get less than what you might otherwise be entitled to. And because of that, far too many employees simply take that verbatim, accept it, move on, and take something less than what they might be otherwise legally entitled to. And that's not to say that these employment agreements don't hold weight. The question is, does your particular employment agreement actually continue to hold and to limit yourself as to what you're entitled by way of a termination, severance pay package, and other obligations that are owing from your employer to yourself? And that is absolutely critical to understand. Because if you don't recognize this, and you don't recognize the potential limitations associated with these contracts, you could very well find yourself just simply accepting stuff and leaving hard-earned money that you are legally entitled to on the table and walk away from it simply because you thought what the employer has been telling you for all these years is in fact correct. Because there is a key consideration that comes into play in this. And that is the fact that with the employment agreement, as with so much else in the employer-employee relationship, the employer is capable of exerting considerable power and influence on the arrangement. And both the law and the courts have recognized this. In that there is an imbalance in the relationship. And when that imbalance goes against what the law is, the courts can come in and your lawyer can come in and even you can come in and say, I've been improperly treated, or more so, the terms of this employment agreement are improper. They have precluded me from getting the rights I would otherwise have been entitled to, the remuneration, the salary, the wages I would otherwise have been entitled to, and I should be entitled to receive substantially more in accordance with what the law is, both by statute and at common law. And why is that? That is because the employer is pretty much able to dictate everything. When you go looking for a job, when you get a job, there is no equal bargaining ability there as to what the contents of the contract are. And the courts recognize that. You come in, these are the terms you're operating by. However, the legislatures have set forth in statute, employment standards legislation, what the specific requirements as to minimums are. And when employers countervail those statutory minimums, either the entirety of the contract or the portions of the contract can be thrown out. And in many cases, it's the entirety of the contract that's thrown out with respect to limitations and restrictions that are imposed upon the employee, such that the employee now is capable of not only getting the statutory minimums, but seeking the basis from common law, which is typically even higher than the statutory minimums, simply because the contract has been thrown out. And that's a real true consideration that employees who have been fired, terminated, laid off, and even those who have quit need to properly consider at the end of their job. And they need to understand this. And they need to review those contracts, those employment agreements, on the basis of whether they were working within the law. And if they breach the law, well, then there are obligations that are owed from the employer that have most likely not been fulfilled. And it provides the employee at that time, given the fact that they don't have to worry about going back to their job, they're out of the job now, that they can pursue what they were legitimately entitled to, what the law said they legally earned or where they were entitled to receive, and pursue those monies. And that is not simply limited to their termination pay in lieu of notice, their severance pay, but it also includes back pay, proper wage calculations that need to be undertaken and that were not undertaken because of what the contract attempted to do to circumvent what the law said. Because the law is very clear, it's detailed, and especially in the smaller jurisdictions, we're talking about provinces outside of Ontario, similarly in certain states in the United States, outside the big states, that do a lot of the work on statutory development. What you will find is that there are exacting violations of the jurisdiction's employment standards legislation and employment standards regulations that puts the entire employment agreement into question and effectively can get the agreement thrown out. And that is a very important consideration, equally from a negotiating standpoint as well as from a litigation standpoint. Because as soon as you're able to come back to the employer and say, look, this is the issue you're running into, this is the problem that we have with it, you can make a case. I'm not saying it's going to be easy. It rarely ever is. The fact of the matter is that employers don't want to concede, or at least they're not prepared to concede too early on. The challenge then becomes making it a larger issue for those employers. Because only when you make it a larger issue, only when you make it really appear to legitimately be impacting their financial numbers, will you get their attention and will you be able to deal with it. Otherwise, they're going to simply perceive it as, oh, it's a David versus Goliath situation where I am Goliath, I have all the financial resources, I have my lawyers on call, and it's not even my money, it's the company's money that I'm going to pay for because whatever I can fight you with is effectively what I save on money. And that's what their belief tends to be. And oftentimes, it's the very same lawyers who drafted those agreements in the first place who are then fighting and defending against it because they have a vested interest in it. Because they're coming in and saying, whoa, no. We drafted this correctly, so their pride's being hurt right now. And they want to uphold what the employment agreement said because they told the employer years ago that these employment agreements were correct and they could withstand legal challenges. So they're telling a story to the employers. The employers are meanwhile not wanting to quickly pay out money, and that's why it makes it difficult. Nevertheless, you have to remember, and there's tons of case law to this effect, that the courts clearly recognize the imbalance in negotiating ability between an employer and employee and recognize that within an employment agreement. And simply the fact that you go and you take the employment agreement to a lawyer and say, can you please review this? Like, if you were on equal balanced terms, yes, maybe that lawyer could negotiate a better agreement for yourself. It's not a partnership. It's an employment agreement. Because if that lawyer were to have negotiated on your behalf and tried to get you completely more equitable terms, completely consistent with the law, every penny that was properly deserved, the employer probably wouldn't have even employed you. They would have said, this is too much a hassle. This person's going to cause too much problems. And that's not what we are offering. We're offering take it or leave it. If you don't want it, you don't need to take it. You can go your own way. And that's how they approach it. So the courts have recognized that. And the courts have only one real basis upon which to protect the employee. And that is when it comes to them, typically at the end of the employment relationship, and they assess what the contractual arrangement was. And really, their only substantive position outside of harassment, discrimination claims, and the like, when it comes to a purely contractual matter, they can look at the contract and say, this contract, which is very much against the employee, is so because it's a violating statute. So you really need to understand how it can violate statute. And because of that, the entire employment agreement is thrown out. Yeah, sometimes they might try to just, and the other side will try to get only parts of it thrown out, but it's effectively the entirety of the agreement gets thrown out. And that's what you got to be aiming for, and then you put yourself at a better position to deal with your former employer and attain what you would legally have been entitled to receive, whether by common law or as set out in the statute. So if you got to look at the employment standards legislation, see what the minimums were, how the requirements were. And as I said before, there's a lot of calculations out there that are being done, in my professional estimation, incorrectly, depending on the jurisdiction. And that creates a lot of vulnerability for the employers. A lot of them don't recognize this. They don't want to admit to it. But if you can challenge them, you can deal with it, and you can really take them to task, and your lawyer can show you where that is, then you have a very good possibility of having a substantive case and getting what you fully deserve. And if you get the right lawyer, they'll work with you and enable you to pursue that money, because they have a vested interest now themselves in succeeding in this matter. And the fact of the matter is, if there is something there upon which to pursue from a legal standpoint, it's more than worthwhile. Because all too often what we're talking about is money that is out there. You've got most of your money, if not all of it, from the termination. Sometimes you got to put a bit of the severance money at risk, yes. But if they could establish that there's veritable statutory money, and oftentimes this could well exceed the severance money, then you're standing in good stead, because then you can pursue this very effectively and with extreme confidence. Yes, it might take time, but it's money that you have earned, so why not get money that you are legally entitled to, having earned it, having done the work, and being legally entitled to it. And that's what we're simply looking for you to pursue. Thank you.